And I think many of you are familiar with ACS, but in case this is your first time attending one of our events, ACS is a network of lawyers, law professors, policymakers, and law students that promotes the vitality of our Constitution and the fundamental values it expresses: individual rights and liberties, genuine equality, access to justice, democracy, and the rule of law. The 2009 through 10 Supreme Court term began, as all of you know, with the controversial holdover from last year, Citizens United, dealing with campaign finance reform. And I'm sure you will hear about that case today. The term ended this past Monday, with the court holding that the Second Amendment applies to the states. And as you recall, the court decided 2 years ago in D.C. versus Heller that the Second Amendment gives individuals the right to bear arms. And there are many other important decisions, but I will leave that to our very distinguished panelists to discuss. We are extremely pleased to have such a wonderful moderator today, Tom Goldstein, and 7 panelists, all of whom will bring insight and expertise to our discussion. You have more extensive biographies of each of the speakers in your handout. So I'm only going to give a very brief background for Tom Goldstein, who really actually needs no introduction at all, particularly to an ACS audience. But I will say just a few of the highlights of Tom's very, very distinguished career. He is the co-leader of Akin Gump's Litigation Management Committee, and he has a practice that focuses on Supreme Court litigation, and he has argued 22 cases before the court on a diverse array of legal questions. In addition to practicing law, Tom teaches Supreme Court litigation at Stanford Law School and at Harvard Law School. Talk about an overachiever. He also founded and publishes SCOTUS Blog, which in 2010 became the only weblog ever to receive the American Bar Association's Silver Gavel Award for fostering the American public's understanding of law and the legal system. And therefore, it goes without saying that we could not have a better moderator today than Tom Goldstein. So join me in welcoming and thanking Tom.
Thanks so much. It's tremendous to get to be here. I know that each of the panelists really thanks ACS for organizing such a wonderful event, but also thanks all of you for taking the time out of your busy days to come and visit with us and talk about the Supreme Court. It's a tremendous turnout and really shows the great level of interest in both the legal profession and the public generally in the Supreme Court at a time of change. So our goal is to reach back through the term and discuss with you what we think the highlights of the cases are, and also make sure that we leave time both to talk about transitions in the court with the retirement of Justice Stevens and the likely confirmation of Elena Kagan, and also to take your questions. So when we talk about the cases, we really regard you as a sophisticated and self-selected audience, so that we're not going to say, well, I'm going to give you 5 minutes about what happened in the case. We really recognize that you all know a lot about the Supreme Court and what's going on, and our goal here is to give you our take on the cases, tell you what we think is going on more broadly with the court and the direction of the law, and make sure that we get to move through the body of things. My goal as the moderator is to say as little as possible. You're here to hear the panelists talk about their areas of specialty, and so my job basically is to be brutal when it comes to keeping us on schedule. We have 7 people who are incredibly accomplished and have a lot to talk about across a huge array of issues, and if we aren't really strict to the schedule, then we just won't get through everything, and you won't get to hear from each of the people who are here. So I want to start with Doug Kendall, who is going to talk about a couple of cases, a body of cases that I've just labeled as conservative civil rights. The idea that the conservatives on the court actually do have a broad reading of provisions of the Constitution, affirmatively invoking it to invalidate different provisions of law. So Doug?
Thanks, Tom. Wow, that was quick. Yeah, so Tom has assigned to me 2 very different cases upon which I have very different views. The 2 cases are the McDonald versus City of Chicago case, which is a Second Amendment case that came out this week. The second case is the Stop the Beach Renourishment case, which is a judicial takings case that came out about 2 weeks ago. I'm just going to handle them in that order and just give you a bit of my take on both of them. So first thing I want you to do is just close your eyes for a second. Close your eyes and imagine if the McDonald case involved some other provision of the Bill of Rights. Think maybe the double jeopardy clause. And think that, okay, it's a African-American plaintiff, Otis McDonald's about a 70-year-old African-American plaintiff, who was alleging that the state of Illinois had tried him twice for the same crime. And imagine that the state of Illinois was alleging, wait, the Bill of Rights and the double jeopardy provision doesn't apply to states, it only applies to the federal government. And imagine they were also saying that it really isn't that fundamental, really isn't important. And I know you've recognized that it has been in previous cases, but in this case you should say it, rather than any other substantive provision of the Bill of Rights, is not really fundamental enough, so it should apply equally against the states. And imagine that the court split 5-4 on that case, with the 5 finding that, you know what, we fought a civil war over this. We fought a civil war over states' rights and the ability of states to violate the rights of individuals. And one of the outcomes of the war was a 14th Amendment, which applies and makes sure that the states comply with at least the specific substantive rights enumerated in the Bill of Rights. And imagine that the courts, that 5 majority, dismissed arguments that, that we should signal out certain provisions for less secure treatment, and that we should do so to protect, and dismiss the argument that we should do so to protect federalism. And then think about the arguments on the other side, which is that, no, really, this provision of the Bill of Rights isn't as fundamental, even though we said so, and we should treat it as less important and less worthy of protection against state action, and states should be able to infringe it more often. And then keep your eyes closed for a second, and think about whether think about a concurrence by an African-American justice. And imagine that African-American justice had written a 60-page opinion that was comprehensive, thorough, and a little bit angry, recalling both the institution of slavery and the history of mistreatment of African Americans and the freedmen in the wake of the Civil War, even after they had attained their freedom, and recounted in more detail than any previous Supreme Court opinion the history of the passage of the 14th Amendment and why the 14th Amendment was necessary, what the framers of the 14th Amendment did to look throughout the country to find the violations of substantive rights, and why they passed the 14th Amendment, and why it is so important that at least the substantive provisions of the Bill of Rights apply against the states. Obviously, the point I'm trying to make is, I think most people in this room, in the ACS audience, in most cases, would look at the 5-4 ruling and agree with the 5 and not with the 4. And I think we can relitigate Heller. I think the Heller case, the Second Amendment case, is an incredibly close case. I'm not sure the court was right in Heller to say, despite the preamble, there is an individual Second Amendment right. But once the court recognizes that there was, I think the McDonald case is an easy case, unless you want to go back and relitigate Heller. And I think the four progressive justices on the court could have and should have said, I continue to disagree with Heller. I will reverse it at any time I can. But if you accept Heller, which the dissenting justices purport to do, I don't see how you say that the Second Amendment doesn't get fully incorporated against state action.
Now, Doug, I was in the room on the last day of the term, and Justice Breyer wasn't just dissenting, he was freaked out and pissed off. Right? And so it wasn't just sort of like we're going through the motions. I mean, he was really, really, really into it. And so what then does explain, do you think, the left on the court so vociferously opposing incorporation?
Well, I think there's just a pretty fundamental breakdown in certain areas in trust between the different wings of the court. And I don't think I think it was basically a matter of whether the dissenting justices believed the majority would be restrained in some respects in interpreting the Second Amendment, right? I think it was basically, as I read it, a relitigation of the Heller case, and I think that the dissent has great points about that. I was actually surprised and disappointed by the progressive justices. I don't see how you can accept Heller and not accept incorporation of that as the only substantive component of the Bill of Rights that hasn't been incorporated against the states.
Do you want to talk for a second about Stop the Beach before we run out of time?
Well, so Stop the Beach I have a completely different view of. It's a much less significant case. It's a takings case. The court 8-0 rejects a takings claim as they should have. It's a crazy case out of Florida where Florida spends millions of taxpayer dollars to protect these beaches that have been eroded by hurricanes. Most of the landowners are absolutely delighted about it, but you have a series of 6 holdouts who say, no, wait, you're taking my property by spending all these millions of dollars, building up my beach, but then not giving me all this extra beach you put in front of my land. It's a ludicrous claim, which was rejected 8-0, and it was taken by the court, as far as I can tell, just to create a little mischief and to kind of address a little pet issue that Justice Scalia has had for the last at least 20 years when he wrote a little opinion against wanting the court to have taken a case out of Oregon 20 years ago. So the court rules 8-0 against this takings claim, but then writes about 50 pages about whether we should have this doctrine of judicial takings. And they split 4-4. It looks like there won't be a judicial takings doctrine in the future because Justice Stevens recused. Justice Kagan will replace him. I suspect that she will not endorse Justice Scalia's little pet peeve of or pet issue of a judicial takings doctrine. And so I suspect the case won't be that significant, so probably we'll reserve more time for later discussion.
Great. So, Paul, can I turn to you for just a second? You represented the NRA in the gun case. The court, in an unusual move, actually gave you argument time as an amicus. I don't know if you have any particular thoughts on the incorporation thing, but I also know that a lot of people wonder, okay, what does McDonald mean on the ground? What now for gun regulation in the states and localities? I didn't know if you had any thoughts about that.
Sure. Let me answer that and say 2 things about sort of incorporation. One, in terms of the reality on the ground, I think the thing that emerges from McDonald is that we know no more today about kind of the standard of review in Second Amendment cases than we did before the McDonald decision. If you go back to Heller, there was a paragraph of, I think what's fairly described as dictum in the majority opinion that provided some guideposts about what isn't going to be unconstitutional and, provided some comfort for states and the federal government that certain longstanding regulations would not be struck down. What McDonald did, what Justice Alito did in a part of the opinion that's a plurality, is basically quote from that paragraph. So, in a sense, he could not have gone further out of his way to provide any additional clarity. It was kind of, I think, a conscious effort to just sort of leave the standard of review issue alone. That's where the real action is going to be here in the future. That's what's going to determine whether or not there are lots of state and local laws that are unconstitutional or not. And that's why, in some respects, to segue over to the incorporation issue, I'm a little surprised that the decision ended up being 5-4, because I'm obviously biased given my representation, but I think the argument for incorporation, if you take Heller as a given, is a very strong argument. And you might have thought, almost as a matter of strategy, if you will, that it might have made more sense for a couple of the justices that ended up in dissent to essentially go along with incorporation so they could have more influence, maybe get some language in the majority opinion that said something favorable from their perspective about the standard of review. But they didn't, and so that's really an issue that's going to be fought out in the future. The only two things I'll say about incorporation very briefly is, Tom, you're the one that picked the topic conservative civil rights. I assume, therefore, you agree with me that it's not an oxymoron. And I think there actually is an opportunity to kind of make common cause on some of these civil rights issues. Another case I argued this term was a case called Kinney A about the availability of attorney's fees under Section 1988. We managed to get an amicus brief in support of the position that I was taking on behalf of Children's Rights Organization up in New York that was an amicus brief on behalf of some conservative public interest groups.
And how do you do with the conservative justices?
Well, I think we did better than people expected, which is to say, on the question presented, we won 9-0. And I think it was, I don't know how helpful that amicus brief was, but I do think that we actually had a very strong argument on the question presented as to whether you could ever get an enhancement. So, I actually think we did very well in Kinney A and much better than I think most people would have expected. I'm not sure that's because of that amicus brief or not. But I do think there are opportunities for common cause. The second thing I would say is just, if presumably you're here because you have an interest in the Constitution. If you do, then I think you have to have an interest in Reconstruction history. And there's lots of places to start. I actually think the opinions in McDonald are a pretty good place to start. Charles Lane wrote a book on the Colfax Massacre that led to the Cruikshank case, which is one of the precedents at issue in this case. That's a pretty good place to start. I'm sure Doug's got some stuff on his website that's a pretty good place to start. But the point is, there really are two periods in American history that are fundamental to understanding the Constitution. Everybody likes to talk about the Founding Fathers and 1789, but the Reconstruction period is every bit as important.
On Kinney A, just to maybe provide the other, what the civil rights groups would kind of give as the other take, not disputing for a second that you did incredibly well in the case and better than people expected. I think that the civil rights groups would say that nonetheless it went very, very poorly in terms of an outcome and what they would have preferred, that the court, while it says that you can get those enhancements, says that you can almost never do it. So not as a question about advocacy and the great success of the litigation effort, but just in terms of whether conservatives actually found common cause on the court with whether you can get these enhancements, maybe not as much.
Yeah, and the only thing I would say on that is, I think there are different views on that. I think most of the amici that supported us, most of whom were what you think of as liberal public interest groups, I think we're pretty pleased with the result. Not maybe in the abstract as to what they would have liked to have seen in the abstract, but I think in a sense they felt this was a bullet dodged. And on the one hand, there is some language in the majority opinion that's kind of a little bit begrudging about enhancements. But I actually think the net effect of this opinion, time will tell, but I actually think the net effect of this opinion is that there will be more enhancements. Because I actually think enhancements are now on a firmer ground than they were before the decision, because you now have 9 justices that, although narrow circumstances and the like, there is a real basis for enhancements. The last thing I'll say, probably more than I should, is just I actually think the real virtue of the decision, the way it came out, is that now that enhancements are at least permissible in the abstract, I think what's going to happen is in most cases it's going to drive the settlement amount on the attorney's fees case closer to the lodestar amount, because both sides are going to at least have some skin in the game. And I think that's actually probably a pretty good result as a practical matter.
Let's then continue on the topic of civil rights, because attorney's fees obviously really important to civil rights litigation. And having skipped over the First Amendment, go back to it. Maybe Monica, and I should be introducing people, but I feel like everybody here is so well known. Monica Yoon, who's counsel at the Brennan Center. maybe talk about the other major sort of path-breaking case of the term that Caroline mentioned, Citizens United and other free speech issues?
So, I mean, I was thinking about Citizens United again this morning, and what was really coming to me was, this quote that was kind of etched on my brain, which was, "The censorship that we confront is vast in its reach. The government has muffled the voices of the most significant forces in our economy." And, and for me, this is a question of worldview. I mean, the majority in Citizens United looks at this country and they say, well, we feel that for the past 60 years, under the law at issue, that corporations have been unable to exert sufficient influence over politics. And that's one worldview issue that comes up in Citizens United. And another one is this question of corruption, because you have to think, Kennedy writes the Citizens United majority opinion, and a year before he had written the majority opinion in Caperton. Caperton, for those of you who need a refresher, was the Massey coal case, not involving the mining, disaster, but, a previous Massey coal case, where the CEO of Massey Coal had a case about to go before the West Virginia Supreme Court, case worth $50 million, and spent $3 million in attack ads to basically take out a sitting Supreme Court justice who he knew would vote against them. And, and then another candidate, Supreme Court candidate, benefited from those campaign expenditures and became justice in this person's stead. Now, the Supreme Court, upon hearing this case, decided 5-4 that this created bias sufficient to rise to the level of a due process violation. So, Kennedy addresses Caperton in Citizens United and basically says, I can't remember the exact way he handles it, but it's very briefly, and it says basically, well, you have a right to an unbiased judge. Which, made me think, okay, so what if we have the facts of Caperton in an election, in a non-judicial election situation? What if you have a situation where a sitting legislator has, let's say, offshore drilling coming before his or her committee, and this person is a swing vote, and is taken out in a primary by a massive negative ad campaign, and someone else is installed in that stead who is a benefit, the recipient of these expenditures. We see these kinds of examples all the time in this area. And so is the Supreme Court saying that then is not a problem? That is not corruption? That's not something that the state has any interest in combating, and not something that the state is able to, articulate a significant or important interest that would justify regulation? And so I think that this worldview of the court is what, I really find myself struggling with when we think about Citizens United and what to do about Citizens United. And I think that one thing that's exacerbating that worldview is the way in which these cases are coming up. I was just chatting with somebody about, remember last summer, and I'm sure a lot of you in this room remember last summer when, there was a very rushed re-argument called in Citizens United, and suddenly all of us were working through the 4th of July weekend, we're scrambling, trying to get our briefs in line, because all of a sudden the Supreme Court had, decided it might reconsider 2 of its precedents and statutory law going back 60 years. Trying to pull those briefs together in a matter of weeks, not being able to get, the facts about how the McCain-Feingold law had developed over the last 10 years. I think that very much influenced the court's consideration of this case and made it impossible for us, I think, to push back against the court's worldview, this idea that they have in the majority's head about what politics does, how it works, what influences political actors.
So, Monica, do you think this is the end of the road for the Supreme Court's reaction to campaign finance regulation, or do you expect still more decisions by this alignment sort of knocking back campaign finance reform?
I mean, I absolutely, there's a real question as to, after the very dramatic confrontation at the State of the Union address, whether the Supreme Court would back down on this issue, whether they would say, okay, maybe we went a little far, let's go a little under the radar now. But I think that the two actions at the very end of the term really kind of put paid to that notion. First of all, in the Arizona case, the McComish versus Brewer case, where I should mention we represent intervener defendants. But in that case, the case involves whether or not so-called rescue funds or trigger funds that are part of the Arizona public financing system. And so that system has been going for like 10 or 12 years. And the idea is the state gives a relatively low base amount of public funds, and then only if the race ends up being particularly competitive, if there's high spending or if some third-party groups come in and are spending above a certain threshold, then rescue funds are granted. Now, the question in the case is whether those rescue funds put a chill on the spending of third-party organizations or on the privately financed candidate, whether or not they feel like, oh, because my opponent might get some money to respond to my spending, I'm discouraged from spending. Now, the district court judge in the case said very clearly as a finding of fact, no, that didn't happen. I mean, basically candidates in Arizona, third parties in Arizona have raised as much money as they possibly can and have spent as much money as they possibly can. There's no bump at the threshold. Despite this, the plaintiffs applied for an emergency. Ninth Circuit unanimously upheld the rule, including a ruling from Judge Kleinfeld, who's, I think, usually quite conservative. And the Supreme Court granted basically enjoined the grant of the trigger funds less than 2 months before the primary elections. Now, we had put in affidavits to the court saying that candidates had already opted into the system and they were only going to get 33% of the money that they were expecting to get. You have people like Governor Jan Brewer, who's locked in a position where her opponent has already spent over $2.3 million. She's locked into $700,000 and can't get additional funds. The Supreme Court created chaos on this, and for a very abstract notion of injury.
Right. So let me actually make sure that we cover all of the First Amendment piece of things. So having talked some about free speech, Andy, can you talk maybe briefly about religion, and then I want to come back to you on an important business case.
Sure. There were two cases involving religion, although they didn't involve the religion clauses. Each of them. Let me talk for a minute, and both were 5-4, and most, not a surprise, most cases in this area do split the court down the middle that way. Let me talk a little bit first about what the underlying concerns are. I think among one side of the court, there's a real concern about the treatment of religious people and religious beliefs by what some might term the governing elite, a sort of a denigration of religious views, and almost a concern that religious people are, in Caroline Product's terms, a discrete and insular minority that really needs the court's protection. And I think you see that trend in the court's grants of the Christian Legal Society case that I'll talk about, and even I think in the Doe case, the case that I guess we may talk about involving the right to keep referendum petition signers' names confidential. I think that's something that's going on up there right now, and I think, along with in religion cases themselves, a view that a lot of the court's Establishment Clause jurisprudence just didn't make any sense, was unduly harsh in sort of walling off religion and had to be stopped. And then on the other side of the court, I think you have what I'd call the more traditional Establishment Clause concern about government endorsement or involvement in religion, and a real desire to maintain, maybe not to the extent that it existed in the 1970s, but to maintain the idea that government really needs a hands-off attitude. And I think that was manifested in these two cases. One is Salazar, it's the Cross on the Mountaintop case, a case which I'm sure people know about, where there was a cross on government land. A district court issued an injunction saying it had to be taken out. Congress passed a law saying, well, we'll just give this land to private parties in a swap and keep it there. And the person who got the injunction went back and got an injunction against the statute providing for the land swap. So sort of bizarre facts. The government then sought review, of course, because the statute had been held unconstitutional. I think the fear of people on the side of this issue that worries about maintaining at least some kind of a distance between government and religion was that this was a case that was going to be used to make it much more difficult for people to bring these claims by really ratcheting down standing in Establishment Clause cases. Paul and I argued a case a couple of years ago called Hine, in which the court limited taxpayer standing in Establishment Clause cases, or failed to extend it, depending on how you look at it. And this was a case about observer standing, which is another form of standing that's used to challenge, in the Establishment Clause context, someone, in this case, there was a former Park Service ranger who went to the mountaintop, literally, and felt that his enjoyment of government land was adversely affected by the presence of the cross. And I think many people thought the court took the case in order to say that kind of observer standing doesn't cut the mustard under the case or controversy requirement, and so you've got to show a more concrete injury, which would have worked a quite substantial diminution of the ability of people to challenge things under the Establishment Clause. That didn't happen because when the court took the case, it found a little bit of a jurisprudential block, which is that standing had been established in a prior phase of the case from which the Solicitor General had not sought certiorari. The case went back to the district court to determine the constitutionality of this swap statute, and the court said, well, as the case comes to us, we really can't reconsider that earlier standing decision. We can just look at this person standing to seek the extension of the injunction to prevent the land swap. And so the standing part of the case is sort of the dog that didn't bark, and the parties, the court split really on the question of whether there was the land swap itself in some way violated the Establishment Clause, and probably not surprisingly, although I filed a brief on the other side, found out it didn't. Christian Legal Society, I think, is something that has much broader implications. This case, again, the court split 5-4 this time in an opinion written by Justice Ginsburg. The part of the court that worries about entanglement prevailed. Again, a very factually messy and complicated case about exactly, this is Hastings Law School, what's the rule about recognition of student groups? Hastings had at different times a policy that said, well, you just have to agree to not engage in discrimination on protected characteristics, and then at another time it had what people now call an all-comers policy. If you want to be a recognized student group on our campus, you got to take every student as a member. You can't have any preconditions. And the court said, well, that was the real policy, and we're going to uphold it. I think what was significant about the case is the dissenters, in an opinion by Justice Alito, said, well, we want to examine this non-discrimination policy, and we're going to find that it violates the First Amendment as applied to religious groups, because that prevents religious groups from limiting their membership to people who have their beliefs and singles out religious groups on that basis. I think that has real implications for the enforcement of non-discrimination policies going forward, and it's going to be very interesting to see how it plays out. But a lot of the court's rationale would seem to say, if you're the Ku Klux Klan student organization and your belief, your message has to do with the inferiority of black people, then the government can't force you to have to admit black people as members, even if the government is in some way recognizing or supporting your group, as it is in this case by giving some funding and some preferential access to government facilities. So I think in this case, the all-comers policy was upheld, but I think it's going to be very interesting to see how this other issue plays out, because most law schools, and I filed a brief on behalf of a bunch of state universities in the case, have a policy that mirrors the traditional no discrimination on the basis of race, gender, nationality, religion, sexual orientation, et cetera. And so those cases are still in the lower courts. There are many of them, and they're going to come back.
Thanks, Andy. Continuing and closing out the sort of civil rights-related docket, Alyssa Massimo, who's the president of Human Rights First, how about other civil and constitutional rights cases that were big in the term?
Sure. So I was going to talk about a couple of cases, very different, but the first, just relating to the speech issues, is the Humanitarian Law Project case, which is a case that tested the constitutionality of the Federal Material Support Statute, which has been back and forth between the court and Congress for some years. And the case is really, it's important for a number of reasons. First, it was the first case in the whole war on terrorism era, really, that was a big win for the government, moving away from the cases focused on detainee issues and more to the tools that the federal government has to combat terrorism. And the court, as you all I'm sure know, ruled 6-3 with Chief Justice Roberts writing the majority, that the statute was constitutional as applied to this question of conduct or speech that this group, the Humanitarian Law Project, wanted to engage in. And this is even in the case where the activities that the organization wanted to engage in or was engaging in was designed to promote human rights and peaceful advocacy. So that's a very important contour now to add to the federal material support statute. And it will have profound implications. And it was a highly watched case for, we didn't file a brief in the case, but as a human rights organization who tends to try to work with groups and advocate towards everybody, peaceful resolution of conflict and human rights standards and compliance with human rights standards, it's going to cause a lot of people to think about, how much of this is speech and can it be construed as support for the aims of the organization. A lot will depend on, how the lower courts interpret the guidance or lack thereof, or the conflicting guidance in some ways of the court's decision. On the one hand, there's a lot of language about how this is very narrow, that it has to be in coordination with, that people can still say whatever they want to whomever they want, but they can't do it's got to be independent, and they can't do anything that's directed to or coordinated with or controlled by the terrorist organization, foreign terrorist groups. And the fact that Justice Stevens joined the opinion would indicate that the court was serious about that this is a narrow ruling. But in practice, it may be very, very difficult, and this is what Justice Breyer pointed out in the dissent, which he read from the bench to underscore its importance. In practice, it may be really difficult to engage in the kind of speech that the majority says it wants to allow without running afoul of the standard. And in particular, if you mix that in with the language in the decision that urges great deference to the executive branch in deciding what is not only who is a foreign terrorist group, but what constitutes support for that group, you can see that it may be very difficult. There may be very little left for organizations who want to try to move the needle with groups that are advocating or engaging in violence, but they may be the future political leaders of countries, and we're going to have to deal with them. And how do you impact that? So I think we're going to have to wait and see. But the question is, will this be chilling on that kind of activity, which ultimately may, ironically, be serving the aims of the overall struggle against terrorism. So one other quick point to mention there is this question that in the majority opinion about whether or not engagement on issues like human rights standards and peaceful advocacy with a terrorist group may tend to legitimize that group. That was particularly troubling to the minority, to Justice Breyer, and it is, you can see, a potentially very open-ended kind of judgment for the government to be able to make and to base its decision on concluding that certain activity is judged material support for terrorism. So that's one of the cases, and I think we're going to have to wait and see what the implications are, how the lower courts deal with that. But I think there's no question that groups that engage in this kind of activity or seek to are now going to be very, very cautious about doing that, and it may ultimately that may undermine the cause of human rights and peaceful resolution of conflict.
Do you want to just briefly mention Samantar?
So Samantar is a case really about the Foreign Sovereign Immunities Act, and it was Stevens wrote for the unanimous majority. It was a very narrow case. It was the decision that was reached was actually supported by the Obama administration, and the question was whether or not this former high official of the former Somali government could claim immunity under the Foreign Sovereign Immunities Act as an individual, and the court ruled unanimously that it did not provide immunity to individuals, and Stevens said, that Congress didn't mention anything about individuals in the Foreign Sovereign Immunities Act, and they could have. But it leaves open a lot of questions. I mean, I think the reason that the case was unanimous and supported by the administration, which is usually quite worried about widening or narrowing the scope of the Foreign Sovereign Immunities Act, is that it was quite narrow, and it leaves to the lower courts whether there are other common law or other immunities that Samantar, who was, I think, the defense minister, former prime minister of Somalia, who was being sued by victims of families of victims of torture. And this was a case that groups like Human Rights First and others who advocate for accountability were very concerned about the possibility of the position that was being advocated here by the Somali government official, if it had prevailed, would have gutted the Torture Victim Protection Act, and which is one of the very few vehicles for accountability, albeit in a civil sense, for serious human rights violations abroad. So in a way, we live to fight another day on this, but we'll have to see how the lower courts construe this, and I think that Congress will obviously be watching that very closely.
Let's then turn to the Constitutional Criminal Procedure Docket, which has had a huge amount of action. This term has been a big, big deal over several terms involving all kinds of issues, confrontation and the jury right and the like. Paul Butler, who is both a professor and associate dean at GW.
So for progressives, there's more bad news than good news. The good news comes mainly from a case where the court says it's unconstitutional to sentence a child to life without parole when she hasn't committed a homicide. And that was a 6-3 decision where Chief Justice Roberts concurred in the decision. I mean, it's kind of consistent with what the court has done in other sentencing cases recently, where it says it's unconstitutional to execute someone who's retarded, and it's unconstitutional to execute someone for a crime other than homicide. Now, the rationale was interesting. Even though most states now allow a child to be sentenced to life without parole, LWOP, Justice Kennedy still found a national consensus against it because most states don't actually impose that punishment on children. It's important to understand what the decision doesn't do. It doesn't prohibit a child from being sentenced to life imprisonment, just life without parole. And it also doesn't prohibit a child from being sentenced to a specific term of years. So there's actually a child in California who didn't commit homicide, but got sentenced to 186 years in prison. And that crime is still, as of now, that punishment is still constitutional. Still, the case is important for a couple of reasons. The U.S. is the most punitive of any Western nation. We have the highest rate of incarceration. And this case continues a trend in which the court is skeptical of this get tough on criminal justice movement. And there's this growing realization that our sentences are overly punitive compared to the rest of the world. And some interesting, actually, international comparative human rights analysis. Justice Kennedy says he understands this isn't controlling on the court, but he wants everyone to know that the U.S. is the only country in the world that imposes LWOP on kids who haven't committed homicide or attempted homicide. And he also points out that this practice violates the UN Convention on the Rights of the Child, which has been ratified by every country in the world except the U.S. and Somalia. If you look at the votes of the individual justices, they're fairly predictable, including Justice Kennedy writing for the majority here. He's probably been the most critical of our overly punitive criminal justice system. There was some concern about where Justice Sotomayor would be on these criminal justice issues because she's a former prosecutor, but in all of the cases this term, she voted with the progressives. The surprise here was the chief. Justice Roberts also voted with the moderates. He didn't think that there should be a categorical rule, but he did think that this sentence was unconstitutional in this case, and so he's carving out kind of some independent territory that he's not a doctrinaire conservative on every sentencing issue. So that's the good news. The bad news, quickly, Miranda, one of the most famous Supreme Court cases ever decided. In 3 different cases this term, the court limited its scope. So in one case, the court said you have to actually speak up. You have to affirmatively say you want your Miranda rights in order for them to be preserved. Justice Sotomayor wrote her probably first major dissent in this case, in which she said that turns Miranda upside down. You have to speak up in order to remain silent. And so it's kind of like chip, chip, chip. In total, none of these cases, overrule Miranda. Police still have to give the Miranda warnings, but it's alive. It's not well. And finally, there was a text messaging case called Kwan. And Mr. Kwan was a police officer who was sexting both his wife and his mistress on the government-issued pager. He'd signed, like most employees, he'd signed a waiver saying that he understood that the government could actually look at what was going on. His employer could look at what he was saying on his pager. But when they did, and he was disciplined, he sued, saying that his Fourth Amendment rights were violated. The case was actually more interesting prospectively because a lot of us thought that the court would use this as an opportunity to outline a theory of the Fourth Amendment in cyberspace. How much privacy should we expect in our texts, in our emails, in our internet usage? And the court expressly declined to do this. It says it would assume for the purposes of its analysis that there is a reasonable expectation of privacy in your internet and cyberspace use, but it wasn't holding that now. So it left that extremely important question for another day. That day is absolutely coming. It, probably would have been better sooner than later, but we'll have to wait and see. The oral argument in that case indicated that the justices are surprisingly in attune to technological advances. Even the relatively young Chief Justice, along with Justices Kennedy and Scalia, they didn't understand how text messages work on a very fundamental level. And so, again, much of the Fourth Amendment analysis or Fourth Amendment jurisprudence, this is the direction it's going in. It's going to be all about cyberspace. Now it's very kind of physically grounded, but this is the future, and we're living our lives. The court did acknowledge, for cell phones at least, we're living our lives on the cell phone, and so it's going to have to determine what privacy means in that context, and it left that question for another day.
Virginia Seitz, following up on the criminal law theme.
I'm going to talk about the trio of very high-profile white-collar cases involving the honest services fraud statute. As everybody here probably knows, the court sharply curtailed the reach of that statute, confining it to cases in which the fraudulent scheme to deprive another of honest services takes place through either bribes or kickbacks. I think there are 4 very interesting sets of potential consequences from this trio of decision. And the first one is kind of a law weenie point. This was not nearly as bad an outcome for the federal government as one would have expected based on the oral argument. First of all, these cases themselves were remanded for a harmless error inquiry, so it's not absolutely certain that Jeff Skilling is going to have a get-out-of-jail-free card. But more broadly, I think the court worked extremely hard to save a constitutional core of the honest services fraud statute. It did so, and this is what I think is truly remarkable, even though it could not sever any particular words or phrases from the statute, it couldn't play the normal interpretive game that you play when a statute is in part valid and in part invalid. this is a unique and very extreme use of the narrowing construction doctrine, I think. Justice Ginsburg said, we will interpret this statute to have limits that are not suggested by the words of the statute. And I think that's truly remarkable, and it's an important interpretive technique. And it is a technique that I think the government may well use in the future to preserve statutes that are arguably overbroad. It's sort of another dot or another way, like unconstitutional only as applied, or severing, or not facially invalid, a set of doctrines now that you can use to save the constitutionality of statutes. This is another, a unique and a very aggressive one. So imagine a gun statute that said possession of a handgun is unlawful. Could you give that a narrowing construction in a case where the person possessing a handgun is a felon? And if you take this interpretive technique to its logical extreme, it can be used in the criminal law setting to salvage a lot of statutes that I think might not have previously been thought to be salvageable. The second interesting thing about this set of cases, I think, is the rhetorical battle that took place between the Ginsburg majority and the Scalia dissent was all over who was most restrained. And that is kind of a unique way to frame the debate, and shows how successful I think the conservative justices have been in turning restraint into one of the highest virtues of a judge. Justice Ginsburg said, I'm more restrained because I preserved something that we all know Congress wanted. Justice Scalia said, no, I'm more restrained. You defined a new federal law. Only Congress can do that. But leaving aside who has the better of that argument, what is most interesting to me, I think, and about the cases, is that the debate was about who most exhibited the virtue of restraint. Third, and sort of more practically, I think there'll be a torrent of challenges to convictions on direct and collateral review coming out of these decisions. And there are going to obviously also be numerous cases raising the question retroactively. I mean, these cases will often involve a court instruction to a jury to convict someone on the basis of conduct that is no longer a crime. And there may even be quorum nobis cases where people who have been released from jail seek to expunge these kinds of convictions from their record, because as you know, these tend to be sort of often high-profile, important cases. We've already seen in the papers since they were decided, Richard Scrushy and Don Siegelman of Health South and the former Alabama governor suggesting that there were problems with their convictions, and Joe Bruno of the New York Senate. So these cases, although they don't have the sort of volume of the cases that emerged after the court's treatment of the sentencing guidelines, they do have the public eye, and there are going to be a lot of very high-profile cases that will be affected, I think. Finally, the last sort of interesting question is whether there'll be another attempt at a congressional fix. I mean, Justice Ginsburg said in her opinion, go ahead and try to fix this, Congress, but, quote, you must speak more clearly than you have. And I think there's certainly going to be a desire in Congress to fix this problem, but whether there's a capacity to use language with the precision that the court opinion demands remains to be seen.
Thanks so much. So, Paul Clement, the question of how to construe statutes to solve constitutional problems. So in Monica's Citizens United case, the court doesn't read the campaign finance statute, narrowly reaches the constitutional question. In Skilling, the court does read the honest services statute quite narrowly to avoid the constitutional question. We had the Free Enterprise Fund constitutional challenge to the peekaboo and what to do about that possible constitutional infirmity.
Right, and what I'm going to do is I'm going to talk about both the peekaboo case, Free Enterprise, and the Comstock case involving a federalism issue, and sort of loosely grouped together on the structure of government. And you really have both axes here of the structure of government, the horizontal axis involving the separation of powers, and the vertical axis between the federal government and the state government. Let me start with Comstock and then go to Free Enterprise and touch on the statutory construction issue there too. Comstock, in my view, is kind of one of the sleepers of the term. It came out the same day as the Florida life without parole cases. I think it got overshadowed in the immediate press coverage. And I think what's lost is that this is a pretty significant federalism case, and that the Chief Justice's vote in particular is very interesting. This was a 7-2 case. The statute that was involved here was a relatively recent act of Congress, 2006. What this statute did is that it said that if you were somebody who was finishing your sentence in a federal penitentiary, so you'd sort of done your time vis-a-vis the federal government, upon release, if the government thought that you were sexually dangerous or sexually violent, they could civilly commit you, the federal government at that point, and detain you beyond the outer length of your original sentence. There clearly are some civil liberties concerns raised by that regime, but this case really came to the court as a federalism case. The Fourth Circuit had struck down the statute as in excess of Congress's power. The federal government sought cert and defended as the statute is a valid exercise of Congress's necessary and proper clause authority. Maybe the most important necessary and proper clause case since McCulloch against Maryland. I really do think that's probably true because the court elaborates on the outer boundaries of the necessary and proper clause. The court's decision is 7-2, but there are only 5 justices that join Justice Breyer's majority opinion. I think, in the way I look at this case is I think ultimately, although I'm sure some of the liberal-leaning justices had concerns about this statute from a civil liberties perspective, on the federalism issue, this was an easy case for the courts left. I think it was a much harder case for the justices on the right, and you see that in the varying different ways that the justices on the right end up responding and voting in this case. Chief Justice Roberts and Chief Justice Roberts alone joins Justice Breyer's majority opinion for the court, which gives very broad scope to the necessary and proper clause. So there's a lot of congressional authority here and not much role for kind of 10th Amendment type notions of state sovereignty. There's a pretty good argument that civil commitment of the mentally ill or sexually dangerous is a quintessential state concern, but that doesn't get a lot of play in the majority opinion. Justice Kennedy, Justice Alito both write short, separate opinions where you can see they're very sympathetic to kind of the practical problem that Congress is addressing here, because there is a real practical problem here in the sense that if you have somebody who is either mentally ill or very predisposed to recidivism, normally the solution there would be for a state using its rules and pre-existing rules for civil commitment to deal with that problem. But when somebody's been in federal, say, detention for 20 years, it may be that there's no state that's the obvious place for the prisoner to go, and you can imagine that states aren't exactly beating over each other, getting in line to take custody over these individuals. So there's a practical problem, and I think Justice Kennedy, Justice Alito reacted to the practical problem, wanted to uphold the statute, but did not want to sign on to this broad scope of necessary and proper clause authority reflected in the majority opinion. Justice Thomas and Justice Scalia did what you might expect, which is to say, well, practical problems, that's not my problem. We're going to apply the Constitution here, and the necessary and proper clause does not extend this far. So they dissented. They were the 2 dissenters. I think the most interesting vote here is the Chief Justice's vote. I think there's really 2 potential explanations for the Chief Justice's decision to join this broad, robust majority opinion. One is that he was just being the chief. He didn't want there to be just a 4-vote plurality kind of mess for the lower courts, and so he joined it to provide a 5th vote. That's the least interesting explanation. The more interesting explanation is that we have, when it comes to federalism issues, a very different Chief Justice than Chief Justice Rehnquist. I cannot imagine, no matter how much Chief Justice Rehnquist liked being the Chief Justice Rehnquist could have joined this majority opinion. And I think the conventional wisdom, of course, is that Chief Justice Roberts for Chief Justice Rehnquist was a switch that made almost no material difference. But I think on federalism issues, it may well. I think Chief Justice Roberts is much more a Fed, and by that I mean a former federal government official, compared to Chief Justice Rehnquist. I think that could play out in things like the ongoing constitutional challenge to the mandatory coverage provision of the health care law and in other areas. So I think it is a very significant decision from that respect. Briefly, the Free Enterprise Clause case involving separation of powers, this is a case that I have to say I'm really left scratching my head. I don't know whether this is a very important separation of powers cases or this is a case that's not only not very important for other cases but isn't even really important to the plaintiff. The reason I say that is because the court rejected sort of the broad separation of powers challenges, the appointment clause challenge that would have taken down the whole statute. They said there was a removal clause problem, and particularly the kind of feature of the statute that they were offended by was the double for-cause removal. The idea that, even though it doesn't say it in the statute, SEC officers are removable only for cause, and then the members of this board that was at issue, the accounting board, could only be removed by the SEC commissioners for cause. And so the conclusion of the majority was that the board members were too insulated from the president's control, and therefore there was a removal clause problem. Now, how did they solve this problem? They essentially struck the removal provisions from the statute. This is why Tom sort of said, yet another kind of example about how the court deals with unconstitutional provisions. They strike it out and essentially say that going forward, with those provisions removed, we'll just default to the notion that the board members are removable at will by the commissioners of the SEC, and therefore there's no more double for-cause removal, no removal clause problem. We're going to go on in business as usual. And what do the plaintiffs get for their trouble of bringing their case all the way to the Supreme Court of the United States and winning? They get a declaration that the removal provision is unconstitutional. But these particular plaintiffs didn't even have like a challenge to any specific action of the board. So prospectively, everything the board does presumably is okay because the removal provision that was the problem has been excised. These plaintiffs didn't challenge any retrospective action of the board, so I don't even understand how they had standing. Seriously, I don't know what it was that gave them, because declaratory judgment is not a door prize. It's something that is the end product of a litigation in which a plaintiff has standing. And all of this is kind of unexplained in the majority opinion. And so, like I said, the reason I think it may be significant, so that's the reason why I really am scratching my head as to whether the plaintiffs even won. But as to the significance, there were 5 votes here for a very formalistic approach to the separation of powers. And the consequences in this particular case were not enormous. There are other issues down the line where having 5 justices with a very formal view of the separation of powers with very little deference to the views of Congress and the executive branch, which remember here, the executive branch was not complaining about the interference with the president's authority. Both the Bush administration and the Obama administration said they thought the statute was constitutional. So on that ground, the 5-justice majority went one further than the executive branch in protecting presidential power. So there is the seed there of a decision that could have significant consequences. The ultimate resolution here became so narrow that I think it's hard to read too much into the decision. I made a point that Justice Kennedy did not feel the need here to have a separate opinion, kind of taking a narrower view. But I think the answer to that may be the majority opinion was so narrow, you couldn't get any narrower than it. So there was no sort of room for that kind of concurrence. So I think it is an interesting decision, but I think it is a little bit of a head-scratcher at the end of the day.
All right, and finally, before we turn to the transition of the court, Andy, can you talk briefly about the big patent case from the term?
Sure. This is the case called Bilski, and just to sort of, again, give a little context, the Federal Circuit was created so there'd be national uniformity on patent issues, and for many years the court didn't take any patent cases. But for the last few years it's taken them, and I think reversed in just about all of them, and indicated sort of an unhappiness with the way the Federal Circuit is going about its business. And in the cases from a few years ago, what you could read between the lines of the court's complaint was, gee, the Federal Circuit is sort of acting as if our general jurisprudence doesn't exist. It's making up a new rule for when you get injunctions. It's not looking at our general principles about declaratory judgment. It needs to sort of be more analytical. So in this case, the Federal Circuit, where the question is, what kind of processes are things that are patentable, what does that word mean? The Federal Circuit took the case en banc. The chief judge wrote a long opinion analyzing all of the precedents and came up with a test, and the Supreme Court still reversed. And it didn't reverse the judgment. Everybody on the Federal Circuit agreed that this particular application wasn't patentable, and everyone on the Supreme Court did, but it rejected the test for what a process is that the Federal Circuit laid out and basically said, no, you didn't get the message. You adopted a test that says to be patentable, a process has to be attached to a particular machine or has to transform an article. But in our cases, we were very explicit in saying those are two tests that work, but they're not the only test. Basically, why didn't you understand that? And then you adopted, you sort of hinted that these things called business method patents, which are quite controversial, aren't patentable. And there's nothing in the statute that says what business method patents are or that excludes them from processes. So using the way we interpret statutes, there's nothing you can do to exclude them. And by the way, there's a very well-settled principle that you can't patent abstract ideas. Einstein couldn't patent E = mc squared because that sort of preempts the field and prevents innovation. Why didn't you just apply that to the patent in this case, which tries to essentially patent the concept of hedging? That's an easy way to dispose of this issue. You still didn't get it right. Justice Stevens wrote a very lengthy and scholarly concurring opinion saying the right answer here is to say business methods can't be patentable because he went back to the pre-Patent Act, pre-Constitution history of patents and traced them all the way to the present and said this is an overreach. This should be gotten rid of. But although some observers think maybe he had 5 votes at the beginning of the court's deliberations, he didn't have them at the end, and Justice Kennedy did.
So, but tell me, why do you think just the case breaks down on the Stevens opinion on ideological lines? Essentially, why is it that the left seems to be opposed to business method patents and the right would be for it? Is it what would link into ideology there?
I think it's less ideological than an approach to statutory interpretation. I think the word process is in the statute. And there has been, post the State Street decision in 1998, which is when the Federal Circuit said that business methods can be patentable, Congress enacted a statute that referred to business method patents and how they should be treated. And under the way that the conservative wing of the court approaches statutory interpretation, that makes it very hard to say business method patents per se are excluded from process.
All right, we have 20 minutes left. I want to divide that between 10 minutes to talk about the future of the Supreme Court, which we should be able to cover easily, and leaving a little time for questions. So if we can just start with Doug and move in this direction to get a thought about the retirement of Justice Stevens and or the likely confirmation of Elena Kagan.
Well, I think the retirement of Justice Stevens is an enormous blow to the progressive wing of the court. He has been the leader of the progressive wing. He has been, I think, the greatest writer on the Supreme Court across the board. I think he has enormous power through the seniority that he's had on the court in terms of assigning opinions. I think no matter who President Obama picked, the court was going to move a little bit to the right just because some of those traits, the greatest writer, the person who gets to assign a lot of opinions, will be gone. I think we should, all take a second and just, rever Justice Stevens as we all should. In terms of, but I've been like you, Tom, live blogging the Kagan hearings for the last 2 days for Huffington Post and watching every second of it. And I have been just enormously impressed with Solicitor General Kagan. I think she has done, I think she has testified in a way that will be the model for every subsequent Obama nominee. I think her answers, she has simultaneously, kind of endorsed the good of the conservative model of judging John Roberts' umpire while also distinguishing what makes a progressive jurist different in a way that I think is incredibly compelling. I think everyone should look through the transcript of that. I think, I think everyone on the progressive side should be appreciative that we have a nominee who gets up there and can explain what the progressive legal project is about in such a compelling way.
Thanks.
Well, I really agree with that very much on both the loss of Justice Stevens and the impending gain of Elena Kagan. I'll just add maybe one or two thoughts to that. One thing from our perspective as a human rights organization acting globally and thinking about how other countries view United States jurisprudence and the role of the United States in the world, one of the things that really I think would be a legacy of Justice Stevens is his recognition of and looking to international human rights standards, in Atkins and Lawrence, Roper, just really have established that, I hope established, the comfort of the court to look to those standards as relevant. And I hope that when she's confirmed, Justice Kagan will do the same. I was thinking about, Kagan argued the Humanitarian Law Project case. Stevens joined the majority in that case. It was, in some ways, you can see it a little bit as a handoff. But there are reasons that I think to be a little bit concerned on these issues of counterterrorism rights and the role of the executive in the so-called war on terror, which she endorsed that concept, I think, in her previous confirmation hearings. And that framework, which is not, the court's embraced it, so it's not that it's going to mean a big change, but that is going forward going to be a framework, I think, that that can cause a lot of havoc with, as we've seen already in the past, with questions of rights of individuals who are caught up in this so-called war.
Paul?
I think that civil rights in this transition is going to take a hit. The way that Doug told the McDonald story is not unlike the way the Supreme Court described that gun rights case, almost as a rights, as a race case. And it's significant, I think, that in this case, the 5 conservative members of the court finally see an African-American claim for civil rights that they support. Those same 5 justices in the Seattle school desegregation case and the New Haven firefighters case, affirmative action case, they didn't get it. Somehow, in this case, they do. And Justice Stevens was extremely bold after Justices Brennan and Marshall, probably the most outspoken on civil rights. And with Kagan, again, I think she's going to be a great justice. I've known her since we were in the same section in law school in 1984, and I fully support her nomination. But important questions have been raised about her civil rights record, both hiring, her diversity in hiring as dean at Harvard Law School, some policy positions that she took when she was at in the Clinton administration on racial profiling, on the Race Commission, on the crack powder distinction, and even during this nomination process. Justice Marshall's legacy has been trashed by the Republicans, and I haven't seen the vigorous defense of his work that I would like. So again, I think in time, she's probably not going to have the same decades that Justice Stevens had. I think in time, she'll be fine on civil rights, but for the foreseeable future, I think the impact will be strong.
2 things that interest me about the transition: the move for the first time next term to having 3 women sitting on the Supreme Court. I'm a firm believer in the power of critical mass. The level of comfort increases with numbers, and I think it'll be interesting and relevant that for the first time, I think it's gone beyond, I don't want to use the word tokenism inappropriately, but for the first time, a significant enough group of women on the court, I think, to see whether that has any impact or not. It'll certainly have an impact on their own perceptions of their work situation. The second thing I'm interested in is how it might, on the less interesting question than on the merits, is maybe the question of the composition of the court's docket, whether she's going to be in the cert pool or not, and whether she's going to be interested in expanding the number of cases taken, and whether there'll be different types of cases that interest her as a cert granting, having a vote in the cert pool. So I think the composition of the docket might be also affected by her interests, which I do think are she has a significant interest in executive power, and I think the transition to having 3 women on the court is significant and important, and particularly for women watching the court.
One small thing you might see there is it seems like Justice Stevens has been very attentive to the death penalty docket and the claims of ineffective assistance of counsel and the like, which has been a real priority for him, and could be less of a priority for her.
And similarly, he's the last voice, I think, of real concern about what the majority of circuit courts think in a case. I mean, showing real deference to circuit court majority on a variety of legal issues.
Well, I think from the hearings, the most important thing that Elena did was not embrace the role of a FIFA referee as the model for the judicial role. I think that was very wise, and I think as a result, she will be confirmed. In terms of the transition, I guess I just two very quick thoughts. One, Doug touched on this, but I think probably the single most important dynamic change will be the fact that now, every time Justice Kennedy joins with the court's liberals for a 5-justice majority, he will have the assignment authority over the opinion and can decide whether to keep it himself or to give it to one of his colleagues. And I think that shift from that role being Justice Stevens's to being Justice Kennedy is going to make an impact on the decisions as a practical matter. Maybe in subtle ways, but I think that will be one impact just as a practical matter. The other thing is I was struck by Justice, as a lot of people were, by Justice Stevens' vote in the Humanitarian Law Project case. That's not the first time that he's provided a 6 vote for a relatively conservative outcome. He did it in the Indiana voter ID case. He also did it in the Medellin against Texas case. And there are other examples. That makes a difference. As I remarked, I think it's really hard to call the Indiana voter ID case Bush v. Gore 2 with Justice Stevens in the majority. And so sometimes 6 votes matter, not as much as 5th votes, obviously, but 6 votes matter. And I think Justice Stevens' tendency once in a while to surprise. He was an idiosyncratic justice in some ways at the beginning of his career. He, I think, emerged as a leader of the left, but he never lost his individual voice, his individual distinct view of issues before the court. And if that's lost, I think you may see a few less 6-3s and a few more 5-4s.
I think with, for the issues that I work on, which are primarily campaign finance reform, I think it'll be very interesting to have someone who is not a judge, someone who brings some real-world experience and particularly some government experience to the bench. I mean, right now in my field, the majority is on this kind of deregulatory rampage, and they are not stopping for facts. And Justice Stevens and Citizens United provided a magisterial dissent, but I mean they've heard the magisterial dissent. And what I think might be interesting and something that might in fact slow them down is to say these independent expenditures, for example, these things that Congress enacted this law saying we as members of Congress believe that these expenditures would corrupt us. And for the majority to hold as a matter of law, no, you cannot be corrupted by independent expenditures. I think what's needed there is maybe not theory so much as a dose of reality. Justice O'Connor used to provide that dose of reality, and I feel like her absence is sorely missed.
Yeah, on the other hand, with the loss of O'Connor, then Souter and Stevens as kind of the intellectual leaders of the pro-regulatory side, you could see them losing ground conceivably.
I agree with a lot of what's said. To make 2 points, I think Justice Stevens will be missed in many ways, but one maybe minor way is an oral argument. He was somebody who actually asked questions, first of all, very politely because he's a very polite guy, but also less often to score points or convince his colleagues. Sometimes he did that, but most often because he actually cared about the answer and wanted to understand something about what was going on in the case. And I think that dynamic will be missed given a lot of what the other things that go on in the argument setting. I think one interesting question that comes from the hearings, the liberal side of the court, it seems to be, has missed desperately someone who is as good a communicator as Justice Scalia. I think a lot of the change in the legal environment over the last 25 years is attributable to him and his ability to formulate ideas in a way that they're understandable and very powerful. And I think she showed some of that in the hearings, and it'll be very interesting to see when she starts speaking through opinions whether that will carry through.
Thanks so much. All right, so we do have 10 minutes left for questions. We're going to start, as is the tradition at the Press Club, with the media. We have microphones, and so if you will raise your hand, we'll have a microphone brought to you. And if you'd identify yourself, please, and who you want to answer your question in the first instance.
Hi, Lawrence Hurley from the LA Daily Journal. Just wondered if anyone wanted to talk about Doe versus Reed, the story of that case, which I thought was interesting, how they issued the stay. It seemed like they wanted to do something, but then they ended up 8-1 vote affirming the Ninth Circuit.
Monica?
I'm happy to take that. I mean, they did affirm the Ninth Circuit, but I think most commentators, and I agree with this, think that they punted the major issue. Doe versus Reed is a case about disclosure of petition signatories, and the particular plaintiffs in that case who had, I guess, opposed gay marriage on this particular ballot initiative, said that disclosing their names and other information off of the petition was causing them to be subject to harassment. And the court's opinion basically said, well, we don't think that that's grounds for a facial challenge, an as-applied challenge based on, people, particular circumstances of harassment, however, is very much another story. And then the various concurrences kind of laid out what quantum of harassment the various justices thought would be appropriate. Now, where I differ from, I think, most of the coverage on this case is, it's not a complete punt because the Chief Justice's opinion in Doe versus Reed frames the issue up in a particular way. They say, well, some issues may be particularly controversial and may create a significant risk of harassment, and on those issues, then an as-applied exemption may be warranted. Now, framing that as an issue-based question, as opposed to an associational, a group that is, feeling threatened-based question, is, I think, a move that really went unnoticed, but which is really important. I mean, you can imagine in a gay marriage case that you would want harassment to be applied to a group that might be persecuted, but for example, you might feel differently about a business corporation weighing in on a social issue such as gay marriage, as business corporations have been doing through organizations like the Chamber of Commerce.
The one thing I would also say is we have talked about a series of cases. We talked about the judicial takings case. We talked about Free Enterprise Fund. And Lawrence, you mentioned Doe v. Reed, where the court seemed to step into a case and headed in a more conservative direction and indeed issued a stay in Doe v. Reed. And then kind of the air ultimately went out of the balloon. So it looked like several times where the court was setting up a significant doctrinal move but didn't have the votes. Next. Okay, over here.
Hi, Tony Morrow from the, you got it?
Yep.
Okay. Tony Morrow from the National Law Journal. The Democrats during the Kagan hearings seem to have tried to paint the Roberts Court as the enemy, the tool of corporations. And I'm wondering whether you think this term, the court fulfilled that role apart from Citizens United.
Andy?
I actually looked back at this question the other day, and if you put Citizens United to one side, it's actually quite a mixed bag for corporations. There were some significant cases in which corporations, or the side of the case that corporations wouldn't ordinarily support, like the Lewis case, for example, about discrimination plaintiffs. There was a Merck case and a Jones v. Harris case, some cases both about securities litigation. There was the Shady Grove case, which is about the ability to bring class actions in federal court in a very narrow circumstance. The business side lost in all those cases. Now, there were cases that they won, but I think if you actually tote them up, it comes to and put Citizens United to one side, it comes to a fairly balanced year on the sort of core business type issues, which is interesting.
I'd actually, though, like to add to that. If you looked, and we've done this, just a comprehensive study on the success rate of the Chamber of Commerce in cases in which they file a brief. And if you look at their success rate this term, they won 13 of the 16 cases in which they filed this term. And they've won about 68% of the cases since Justice Alito joined the court. If you look at the votes, on average, the conservative wing of the court votes for the Chamber of Commerce about 76% of the time. The four more progressive judges vote for the Chamber about 40% of the time. So the conservative wing tilts more heavily towards the Chamber's position than the progressive wing tilts against it. So that doesn't include every business case, and there's certainly some cases this term where the court didn't go as far as the business community wanted them to, but there's also cases like Citizens United where they went beyond their wildest dreams and have allowed corporations to really have a overwhelming influence on the electoral process and drown out the voices of we the people.
And Tony, I'd make one other point in response to your question. I'm not sure, I think there was some element to the Democrats' critique in the hearings that was sort of corporatist court, but I think you also saw an argument sort of mirroring where Republicans have been in the past, that this is a court that's imposing its policy preferences through judicial decisions. And I think you saw that marshaled beyond the corporate context in a way, more aggressively, certainly, than I've ever seen it before. And I think, and labeling that judicial activism. And I think, to me, that was a big message of the hearings.
Ken Joseph with CQ Press. Doug, you started by saying there's a great mistrust between the two ideological blocs. We were told when Kagan was nominated that she's a consensus builder, yet none of you said she'll build consensus on the court. Was that omission inadvertent or deliberate?
Oh, well, I think General Kagan has the potential to build consensuses. You just saw in her personality this why she has garnered so much conservative support. I think she put the point very well, though, in her testimony, which is that you shouldn't view the role of a justice as kind of this log-rolling lobbyer, efforts to trade votes. And I don't know. Justice Stevens was able to win consensus on the court in certain issues just by his standing and by, in some respects, his willing to be the sixth vote and to kind of be the institution of the court. I think that's, and so on some of the war on terror issues, I think as a former, as a World War II veteran, as a code breaker, as a genuine hero in that time, I think he was able to win the votes of some of his colleagues in surprising cases. I think that takes a long while to develop. I don't think it's something that Justice Kagan will be able to go on the court and do immediately. But I'd be interested in other people's view on that.
A last question from anyone?
Bob Ritter with the American Humanists Association. Does anyone take General Kagan's view that there's really settled law? I really got the impression from her comments that while she was saying that there was settled law, that she will be distinguishing case after case. And I was wondering what your thoughts are on that issue.
Well, my takeaway from what she was saying, and she was then asked follow-up questions about this notion of settled law, is that she wasn't attempting to draw nuanced lines between levels of precedent and super precedent and the like. That she said, I thought, repeatedly, that decision will get the respect that it's due as precedent, and didn't try and say anything more than that. She didn't want to get into the business of suggesting she was more favorably inclined to one line of cases or the other. And so I think she was just saying, with respect to Heller, for example, that's the precedent of the court. It deserves to be treated as precedent. On Heller, actually, it was interesting because just the day before, the left of the court had launched an assault on Heller and suggested that it would overturn Heller, whereas she seemed to treat it as more fixed and binding. But in general, I just don't think she was trying to avoid drawing distinctions.
Yeah, I think that's right. I think she was actually quite careful to say binding law, settled precedent, those just mean it's a precedent. They don't mean that it's invulnerable. A couple of times she said, I don't have any present plans to overrule any cases, but I think she was very careful not to commit herself to anything.
All right, we are right on schedule to finish. Please join me in thanking the panelists, and thank you all for coming.